MSW Media.
I signed an order appointing Jack Smith.
And nobody knows you.
And those who say Jack is a fanatic.
Mr. Smith is a veteran career prosecutor.
Wait, what law have I broken?
The events leading up to and on January 6th, classified documents and other presidential records.
You understand what prison is?
Send me to jail.
Hey, everybody. Welcome to episode 34 of Jack, the podcast about all things special counsel. We've been doing this 34 weeks now. It is Sunday, July 23rd. I'm Allison Gill.
And I'm Andy McCabe. Allison, we may have a few news stories this week in the special counsel investigations, plural. So first, Trump has been sent a target letter for the January 6th investigation. So just let that sit in for a second. In addition, we have more witnesses appearing in front of the grand jury, Trump allies, including none other than Will Russell. And we have some, what I would call, I guess, indications or maybe a willingness to cooperate from former Arizona Governor Doug Ducey, and a subpoena from the special counsel team for the State Farm Arena video footage. That's got to be huge. And continued scrutiny of the Willard War Room.
Yeah, and every week we wonder, like, what could possibly be next.
Totally.
I mean, we're on, I think we're full on indictment watch now, with the reception of that target letter for the coup. And we also have Bernie Kerik in talks with special counsel, but that's according to his lawyer, who is parlatore, so grain of salt.
Yeah, shaker of salt, maybe? I don't know.
That tube of Morton's
right.
of salt. And we just heard today, Judge Aileen Cannon has set a trial date for the documents case, the Mar-a-Lago documents case. She has set that for May 2024, handing another loss to Donald, who wanted this to take place after the election, and it still might. We need to be clear on that. And he also recently failed to get the Manhattan hush money case moved out of the Manhattan district attorney's, state court and into federal court. He failed. And he also lost his bid to retry the E. Jean Carroll case, the one where he ended up, they determined he was a rapist and had to pay $5 million. And that was, by the way, the language that the judge used when denying him the ability to redo the whole trial. She's like, look, it is by definition rape. So
there you go. It is what it is. Tough week for the Trump legal team. There's no doubt about that. They looked good, I thought, on Tuesday when they had the arguments in front of Judge Cannon. And I know we're going to talk more about that later, but man, things took a nosedive for them as we finished out the week. But anyway, so should we move on to round one, which is, of course, the target letter?
Yeah, I thought that was probably the breaking news of the week. I thought it was very pointed that we had one of the authors of the model prosecution memo on last week who really wanted to get that model prosecution memo out. And then lo and behold, 48 hours or so later, but actually the target letter went out that Sunday, the same day that our episode aired.
That's right. Norm Eisen sliding across the finish line there with incredible timing. I mean, that
was
very nice. Nicely done.
And I want to talk a little bit about, I think Rolling Stone was the first to break kind of what was in the target letter. ABC confirmed, CNN confirmed, NBC confirmed, and then, oops, they all got it wrong. and I'm sitting there like, 242? Okay, I mean, I'll write an analysis on this, but that doesn't seem to fit. And I'm talking about Title 18, U.S. Code 242, deprivation of the civil rights under the color of law. And it didn't really seem to quite fit based on what we spoke to Norm Eisen about. But let's talk real quick about, first of all, the other two things. That they got 371. Well, they didn't give us numbers. I wish if they would just give us the numbers instead of a broadly worded definition like conspiracy to defraud the United States. But we know that to be 371.
Of course, yep.
We were expecting that. That's one of the two crimes Judge Carter found more likely than not occurred with Donald Trump and John Eastman and used that to pierce attorney-client privilege with the crime fraud exception when the January 6th committee was trying to get Eastman's emails. So we've been familiar with 371, right?
Yeah, it's been used many times before. Typically in federal practice, you see it used against people who commit some sort of fraud, like stealing government funds, right? If you committed like Medicare fraud or Medicaid fraud, or let's say you were accused of receiving, you remember the COVID money that was coming out to help businesses keep their employees. If you filed a fraudulent request for those funds and received it, you could be charged with 371. Of course, you need a co-conspirator. So it's generally used in that way. I think it fits quite nicely with what we expect the factual allegations to be in the January 6th case. So 371, not a surprise. That was right down the middle.
And then they said, Rolling Stone said witness tampering. And I immediately came out and said, this is what they said when they had the documents. Rolling Stone was the first to find out what was in the documents charges before we saw the indictments. They also called it witness tampering, but it was actually 1512 is broadly the witness tampering statute, right?
That's correct.
In the
that's
documents
actually
case,
the title of the statute, witness tampering. So I can't throw a rock at them for saying that, but our listeners know better because we've been talking about this for months.
Years, since Liz Cheney started uttering the words way back in 2021, as a matter of fact. But, with the documents case, it wasn't witness tampering. Well, it was 1512K, 1512AB2, and 1512C1. Now, what we know the witness tampering to be in this case, I'm almost 100% certain it was 1512C2, obstructing an official proceeding. We've been talking, it's what they've charged most of the January 6th on the ground rioters with. That kind of helps with the conspiracy charge to put those two and two together. So 1512C2, 371, that's also the second statute Judge Carter said was more likely than not committed by Trump and Eastman to pierce attorney-client privilege with crime fraud. So we have those two. Not a surprise. Then we're expecting, because we had just talked to Norm Eisen, right? Well, Andy, I got to be honest with you. I thought it was just going to be 371 and 1512C2 until Garland hit the Oath Keepers with seditious conspiracy charges, got the convictions, until Garland came in and wanted to file a notice for appeal of the Oath Keeper sentences because they were too short. Garland came in and withdrew the certification or representation of Donald Trump in the E. Jean Carroll case. I'm like, all right, kind of a baller.
Yeah.
Maybe he'll go with what Norm Eisen had recommended in the model prosecution memo, which was 2383 inciting an insurrection. But we didn't see that. Instead, we saw 241, which is Title 18 U.S. Code 241.
Yeah. So, and that was the one that kind of threw me the curveball as well. You and I were texting over the news, and I was like, geez, I can't. Because, of course, they mistakenly reported it initially as 242, which is essentially the denial of constitutional rights under the color of law. That's the go-to statute that you use in any federal civil rights investigation of excessive use of force by the police. So it's that under color of law requires that you were in some position with legal authority and you essentially exceeded that legal authority in an effort to deprive someone of their constitutional rights. So that just did not seem right.
I mean, it's used in Breonna Taylor case, the George Floyd case. And so then, Maggie Haberman, and then right following up very quickly was Hugo Lowell from The Guardian, reported that it's actually 241. Right. And the concept is the way that we were trying to apply 242 to what happened on January 6th, that application is still the same with 241.
Correct. Yeah.
But now it's almost like we were trying, it's almost like I was trying to bend it into fitting 242, and then somebody's like, oh no, it's 241. I'm like, oh, well, this sounds like exactly what I was thinking it should be. Yeah,
it's essentially you've removed that element of under color of law. And it's a basic conspiracy. So again, at least two people have to have an agreement and commit an act in furtherance. That's a conspiracy.
Yeah, I have the verbiage right here, actually, if you want to.
Let's go through that.
Yeah, the first part, if two or more persons, as you said, Andrew, conspire to injure, oppress, threaten, or intimidate any person in any state, territory, commonwealth, possession, or district of the free exercise of enjoyment of any right or privilege secured to him by the Constitution. Basically, two or more persons conspire to injure any person in the free exercise of an enjoyment of a right or privilege that is secured to that person under the Constitution or the laws of the United States, or because having so exercised the same, right? The second part made me laugh.
Yeah, I'm not so sure they're going to use this part, but...
If two or more persons go in disguise on the highway.
Disguised as what, I wonder? Okay, let's put that aside for a minute.
It's really specific.
One of them is wearing a sheet as a ghost costume, or maybe not. I don't know.
We would have gotten away with this conspiracy if it weren't for those meddling kids. Anyway, they shall be fined under this title or imprisoned not more than 10 years. So this is a max 10-year felony, or both. But if death results from the acts committed in violation of this section, or if such acts include kidnapping or an attempt to kidnap, aggravated sexual abuse or an attempt to commit aggravated sexual abuse, or an attempt to kill, they shall be fined under this title or imprisoned for any term of years to life, or both, and may be sentenced to death. So
yeah. So it's, I think, helpful to know, like, historically, both of these statutes date back to the post-Civil War period when the government was realizing they needed to do something to protect the rights of Black people in this country who were being oppressed, who were being kidnapped, who were being assaulted in an effort to deny them the exercise of their newly granted constitutional rights. And so that's where they come from. And that's why the second statute, 242, is really directed at police involved in that conduct. However, the courts since about the 1950s have recognized the use of these statutes in the voting context, right? Using these statutes to essentially go after politicians or others who are acting to deny people access to the right to vote, or just some aspect of invalidating their franchise.
yeah, and early on in 2020, 2021, folks like Joyce Vance and Andrew Weissman were saying 241 would probably fit here pretty well. There was a Slate article written in 2020 about using potentially 241, and then we just all sort of collectively forgot about it. You know, I mean, I don't want to speak for anybody else, but and now it's come back up, and so it's also been used very recently. We have a very recent example of a successful 241 charge. That was Doug Mackey. Remember Ricky Vaughn?
That's right.
That's the AKA for Doug Mackey. He was convicted just a couple months ago, March 31st, by a federal jury in Brooklyn for this conspiracy against rights, which is what the name of the statute is, 241. Mm-hmm. And this came from his scheme to deprive individuals of their constitutional right to vote. Now, the verdict followed a 1-week trial before the United States District Judge, Ann Donnelly, and when sentenced, he faced a maximum of 10 years, which is what we said in the statute. And this is from the Department of Justice. As proven at trial between September 2016 and November 2016, Mackey conspired with other influential Twitter users and with members of private online groups to use social media, including Twitter, to disseminate fraudulent messages that encourage supporters of presidential candidate Hillary Clinton to vote via text message or on social media, which in reality was legally invalid. So he was charged and convicted of this particular crime for basically interfering with people's right to cast their votes. Now, how does that apply, and to what part? You know, how we were talking about the multiple prongs of the attempted, interference of the peaceful transfer of power. Is this more of a fraudulent electors type thing where the 241 would apply, in that by conspiring to have people sign fraudulent elector certificates that would somehow impede with a person's right to vote in those swing states? Or is it something else? Like, where would you how would this specifically apply to all the different things we saw Donald Trump doing?
The interesting thing about this statute is you could really use many different facts that we are all very aware of now that took place over the timeline here, leading up to January 6th, on January 6th, that sort of thing. You could use all those different facts as proof of this one charge, right? So it's not dependent on, unlike wire fraud, you need like the specific facts to prove each element of scheme to defraud, use of wire transmission, what have you. This is a little bit different. You could go forward, and we'll see how prosecutors end up doing this. I think the indictment, when it finally arrives, will be very specific in this regard. But there's a lot of things that add to this general idea that Trump was involved in a scheme to interfere with people's right to vote and right to have their votes tallied and counted and applied in a free and fair way. So I think the fraudulent elector schemes fits into that theory very well, and it's a good tangible thing that you can will have direct pieces of evidence about. You'll have numerous participants testifying about their role in those proceedings. We know that from the folks that have indicated they're cooperating recently. So that all works. But even things like the pressure on Mike Pence kind of fits in here, right? If Trump is pressuring Pence to exceed his authority and to basically delay or refuse to certify the election, that also fits this general theory of you, Trump, attempted in many different ways to essentially invalidate the votes of the American public, those people, those voters who voted for Joe Biden. So it's really kind of a catch-all that I think a lot of this evidence could fall into.
Yeah, and I also heard a former Department of Justice official describe it to, I think it was Lawrence O'Donnell, who said, it could also be interfering with our right to a peaceful transfer of power. As protected under the Constitution. Could also be interfering with Joe Biden's right to ascend to the presidency. Yeah, I mean, there's a lot of different ways that I think this could be interpreted, which could attach itself to the insurrection, could attach itself to the Pence pressure, could attach itself to fraudulent electors. Yeah, all kinds of ways that this could attach. It'll be interesting to see if the 241 charge is in the indictment, how it's applied, and what the scheme is. I'm very interested to see that.
It's also very consistent with the 371 charge, right? The basic, you attempted to defraud the United States government of its free and fair election results. It's all the same proof. Yeah. And so for prosecutors, you're basically telling one coherent story. And then at the end, in the jury instruction phase, you are showing them how these two statutes fit in here like pieces of a puzzle. So I think it's kind of it's a clearly a well thought out strategy. Now, we should probably talk a little bit, maybe back up a little bit and talk about the target letter generally, and I'll get back around to what leads me to this point. So we know that on Tuesday, Trump tweets out, or Truth Social, whatever you even call that, I don't know. He posts, I guess, that he'd received the target letter on Sunday night, and the letter gave him supposedly until Thursday to show up and testify in the grand jury if he wanted to do so. And now we also know that the letter included that he was being investigated for these potential violations of these three statutes. So important to know that target letters are not always used. You don't have to send them to the target of a grand jury investigation. There's no requirement on prosecutors to use them. In my cases, very rarely ever use them. Organized crime cases, terrorism cases, you're usually trying to go use the grand jury investigation in a kind of quiet way that the target doesn't know about, so you don't usually use a target letter. They can be used early in the case to put the pressure on a target to try to convince them to come in and cooperate. Most commonly, they're used at the very end for this purpose, to let the target know if you want to come in, and you don't have to, but if you want to come in and explain yourself to the grand jury, now's the time. That being said, there's no hard and fast timing around them. You don't have to indict the case right after the target letter comes out. I think in the documents case, he got one, and then 3 weeks later, he was indicted. You could continue to use the grand jury after the target letter has gone out for any indefinite period of time. And we'll have more reporting on what may be happening in this case on that grounds later. So I think that there's a couple of interesting things here. The one of them is I think we're definitely on indictment watch, but we don't really know exactly when that's going to be. This could go on. We could be in this phase, for the next several weeks. Also, interestingly, these charges, or statutes, I should say, they're not charges yet. At least two of them, right, if I'm counting correctly, require a conspiracy. And so you have to have a co-conspirator. But notably, no one else has received a target letter, according to the reporting, and a lot of people have been asked and come out and said definitively that they absolutely have not. So could Trump be charged singularly in this case and charged with a unindicted co-conspirator? I guess that's legally possible, but highly unlikely in a case like this.
I doubt it unless everyone's cooperating. Like everybody's cooperating, and even then, still, I think you're going to see at least another one.
Yeah,
I know Norm Eisen was like maybe 3 to 5, depending on how much Rudy and Mark Meadows are cooperating. But it's also, somebody had mentioned to me, and I think I discussed this with you actually, that sometimes they don't send target letters to the lieutenants, so that all the lieutenants think that the other lieutenants are cooperating. And that sort of maybe entices them to cooperate against their, well, he didn't get a target letter. Maybe he's cooperating. I better go in and, that whole kind of sort of turning everybody against each other situation. Or it could also be, like you said, they don't have to send target letters to people all the time, and they just might not be sending them to the co-conspirators.
Yeah.
Who knows?
Or they could still be making decisions, like you said. Like, you got a couple of guys here all of whom seem like they might be very strong co-conspirators or very strong cooperators, and they may be still making decisions about like who's in what column. So we'll have to just kind of watch that over the next few weeks and see what happens.
Yeah. And it's also worth noting that the statutes that are listed in a target letter are not an exhaustive list of the statutes that could be charged. So there could still be an insurrection charge there, but there might not be. There could still be, and these, we might not see a 241. We might only see the 3. These are just considerations, right? And it's definitely not an exhaustive list. But I will say that from my understanding and all the experts I've talked to, if you get a target letter 999 times out of 1,000, it's gonna be followed up with an indictment.
Oh, absolutely. Even DOJ defines it like, they say that if you receive a target letter, you are what they call a putative defendant, meaning you haven't been charged yet, so technically you're not a defendant. But prosecutors have significant evidence of your guilt, and they are already thinking of you as a defendant. They just have to get the ink dry on the indictment and have the grand jury vote on it. So you get one of these letters, unless you come in at the last second and work some sort of magical cooperation deal, which sometimes happens, won't happen here, but sometimes happens, you're getting indicted. There's no question.
Mm-hmm. All right, we have a lot more news to cover, including some more things going on with the January 6th investigation. The special counsel's office is underway, and like you said, we're getting toward the end, but there's still some activity. We're going to talk about that, but we have to take a quick break. Everybody, stick around. We'll be right back.
Welcome back. Okay, let's talk about what happened in the courthouse on Thursday. Holy cow, this was crazy to follow.
Boy, as our friend Asha Rangappa would say, whoo boy.
All right, so we'll start out with Trump aide William, a.k.a. Will Russell, was testifying to the federal grand jury investigating January 6th. Are we 100% sure that that's the grand jury he was testifying to? Because I've been hearing in the reporting they're not 100% sure whether he was talking about document stuff or January 6th stuff. But either way, he's in the federal courthouse in D.C. in front of the grand jury. Now, just to keep the names and faces straight.
It was Wyndham in the room.
Yeah.
And since Wyndham is the guy who's the lead prosecutor for the January 6th stuff, that's kind of, I think, why I'm assuming it was the January 6th.
I think that's a fair assumption. I think that's a fair assumption.
I feel like if it was documents, it would have been Bratt or...
Yeah. And it also seems likely, like that seems to be where the lion's share of the action is happening right now. And just to remind people, Will Russell, of course, was I guess a senior aide in the White House. He was like the deputy of the advance team for a while, basically a body man for Trump, and has the distinction of having been around with Trump all day on January 6th. So he's an interesting guy. He's testified in front of the grand jury before, back in September, and I think he also testified to the January 6th committee, if I have that right. But in any case, Will Russell is in there, back in the witness chair in front of the grand jury on Thursday. And what happens after that, Allison?
Well, his lawyer, Will Russell's lawyer, is none other than Stanley Woodward.
Of course it is.
The Trump mafia consigliere, right? And he was in the building, because his client, Will Russell, was testifying to the federal grand jury, and because his other client, one of his many clients, former Trump State Department appointee and January 6th rioter Federico Klein, was getting his verdict in his bench trial from Trump-appointed Judge Trevor McFadden. Trevor McFadden sits at Prettyman, the courthouse in D.C., the federal grand jury, the Chief Judge Boasberg. They're all there,
it's
right?
Just
all
like
the
the nerve center of everything that's happening.
All
with
the
special
January
counsel.
6th cases, absolutely. So here's Stanley Woodward spends a lot of time there. So he's there because he's got two clients. Again, Trevor McFadden is reading a verdict on his client, Federico Klein, and his other client is testified to the grand jury, Will Russell, in the January 6th case. We assume. Now, because of the grand jury testimony with Will Russell, Stanley Woodward, the lawyer, was late to McFadden's reading of the verdict for his client, Klein.
Right.
Now that made Trevor very mad, and he asked Stanley Woodward, the lawyer, why he was late. And Woodward said, "I don't think I can talk about it because it was in the grand jury. It's grand jury stuff. It's grand jury secrecy."
You're not cleared for that information, Judge. I'm sure that went over real well.
Well, McFadden then waived the grand jury secrecy. I don't know that he can do that. And he even made a little joke, you being late to my verdict, talk about obstructing an official proceeding. He even made that joke.
Oh, no. Oh, my God.
So then Woodward told him, if you're waiving grand jury secrecy, he told him in open court in front of reporters that his client, Will Russell, was testifying to the grand jury about matters that pertain to executive privilege. Now, that could be why we've seen high-level prosecutors going in and out of Prettyman this week. Maybe they're fighting a privilege battle on a second or third round of testimony with this guy, Will Russell, or they've gotten additional information from other witnesses and need to bring him back in to button up end of his testimony, which is a lot like what happened with Taylor Budowich down in the documents case in Miami, testifying the day before they voted on a true bill, also represented by Stanley Woodward.
Also explains why Wyndham is there. Right. I mean, he's not going to be, and he's not in every grand jury examination. This is a witness they've been in front of before. There's something important going on there. The privilege battle, I think, maybe explains that entirely, but also the fact that they brought this guy back. Clearly, there's something they want from him that they didn't get the first time, and they believe
the second time.
Yeah, or the second time, and they believe it's important enough to drag him back in and fight it out. So I think that's how we see Wyndham there.
Yeah, so there might have been some privilege litigated right during that day, on that day, Thursday. And, there were some things filed in the docket under seal, but there's a lot of that happening right now. So it's, you can't really pair a sealed filing with something that you think should, is going on that might be a sealed filing. But it stands to reason that if there's a privilege battle, it might have been litigated, an order might have been filed under seal. And I imagine, like 100% of the other privilege battles, that this would have been lost by anybody who was trying to fight it.
Yeah, there's no reason to expect anyone to pull that off at this point. It's been, that's a dead horse thoroughly beaten.
Yeah, no. And then if he pleads the fifth, then you probably get them saying he can't plead the fifth because we're not trying to incriminate him. And then they say, go give him an immunity then. And they're like, oh, fine. It probably that whole thing could have gone down. We don't know. But it was interrupted here by Judge Trevor McFadden because McFadden then sent a court clerk to fetch Wyndham and the other special counsel prosecutor out of the grand jury room, made them sit in the front row of his courtroom while he read his verdict, and then finally had a bench conference, approach the bench, right, with Woodward and the Jack Smith prosecutors. And that's when Ryan Riley was reporting on this NBC. That's when they enabled the court husher. And I'd never heard of this. And I was like, what the frick is a court husher? Is it what it sounds like? Because it sounds like somebody presses a button to make a bunch of noise so you can't hear what the judge said. That is exactly what it is. It's a button that you press in the courtroom that fills the room with some white noise so that you can't overhear what the judge is discussing during the bench conference. So I thought that was pretty fun.
Yeah, that's a good one. You can't hear, in this case, McFadden yelling at the special counsel team, which I'm sure was going on.
Which I'm sure went real well. And I'm sure Chief Judge Boasberg, who actually oversees grand jury proceedings, will be happy to know that McFadden waived some grand jury secrecy rules just across the hall. But regardless, he was satisfied with whatever happened and then sent Woodward and the other prosecutor back to the grand jury room on their merry way. They were there until just short of 5 p.m., questioning, I guess, their witness, Will Russell. There was another witness that was brought in that day, but we don't know who that is, or what case, or if it was with that same grand jury. We assumed that it was. That's what the reporting sort of indicates. But there was another witness that was there that day. Finished up at 5, went home. So these appearances that we've seen, Wyndham's at the courthouse, they're going to vote on a true bill, something's going on, no notable witnesses. They could have been fighting a witness battle. And nobody saw Will Russell or the other witness go in, so they must have entered through the basement. So it's quite possible that even though no notable witnesses were seen, the times that we saw Wyndham at the courthouse doesn't mean that there weren't notable witnesses in the grand jury room. Yeah,
I mean, at this point, anyone who's going in is someone who you're going to be familiar with when you find out, when you hear their name. We've said this many times. This is very clearly the end. You get the target letter out. This was Trump's
target letter went out.
Yeah, Trump's opportunity to come in and testify, was the end of this week. So we're at the end. They are perfecting testimony. They're bringing people in to lock down certain statements, either positive or negative. They are cleaning up some pieces of factual evidence that they think they might need to rebut different defenses, to bolster different parts of the case. This is kind of the trimmings on the house, right? You laid the foundation a long time ago. You built that thing. It's beautiful, 2-story, whatever. The roof is on. It holds water. It's got electric. All the important stuff is there. Now you're just kind of doing the finishing, making it look good. And, it's just a matter of how long that's going to take. We'll see.
Yeah. And like you said, it was 3 weeks from target letter to indictment in the documents case. That's when the target letter was dated, when we finally all were able to see a copy of that, or when media was able to see a copy of that and tell us when it was sent. For Trump to sit on that for that long and not say anything was interesting, mm-hmm. I thought. This time he came out earlier. He came out soon, he didn't wait a week or two after he got the target letter before he put it out on Truth Social. He went 2 days in, and I think that he learned from the last time that if he has more time to fundraise and spin...
Totally.
Between indictment and, to get everybody riled up about the indictment, maybe he'll get less than 14 people showing up to support him, at Mar-a-Lago or at the courthouse in D.C., which I'm sure they will be wholly prepared for.
I think you're absolutely right. This is entirely a political calculation on his part, which is the calculations he's more comfortable with. He and his team feel like this is a good news story for him right now in the short term, getting indicted, which is amazing. I can't believe I'm hearing myself say that. But it is. His numbers are up. His fundraising is off the charts. So
yeah, and DeSantis was announcing something that day, and I think he was just trying to undercut that. We'll see. We'll see what happens. Mm-hmm. Yep, but it could be. They could go this week. They could go 2 weeks from now, 3 weeks from now. We'll keep an eye on the news, and as we see more witnesses go in, we know it's kind of they're still working on tying up the loose ends for a minute. Maybe finally wading through the final last holdouts on privilege. And we do have some reporting from CNN that there are people who are going to come and talk next month to special counsel. So we'll see how that could impact when an indictment is handed down, when it's voted on. All right, we're going to take another quick break, and then we have some news about some other testimony going down. And like I said, that very great reporting by your colleagues over at CNN on some of the things that are winding down and happening in the January 6th investigation. We'll talk about that. We're just going to take a quick break first. Everybody stick around. We'll be right back. Welcome back. All right, so NBC News has confirmed that former Arizona governor, I like the sound of that, by the way, because I'm really digging Katie Hobbs right now. Former Arizona Governor Doug Ducey is said to be cooperating with special counsel. What are your thoughts on that? Because it seems like in some cases, the Department of Justice wanted to leave the state and state officials and state elector stuff up to the states. But then in other cases, we've got, and we're going to talk about something in Georgia as well. We've got Jack Smith's investigatory tentacles all up in the program. So what do you think about the Doug Ducey potential cooperation and how that fits in with perhaps the target letter that we saw?
Yeah. So I think over the last few weeks, I've been feeling like the infamous pressure campaign on the states. So that's the call to Raffensperger, these calls to Doug Ducey, one of which he notoriously refused to take.
As he was signing the certificate for Biden.
Yeah. Good call there. I've been thinking more and more that stuff the special counsel team might leave on the table or leave for the states to follow up with. Of course, we know that Georgia is, maybe Michigan as well now. Now, the fraudulent electors, the actual impaneling of fraudulent electors, their execution of paperwork and submitting it to the federal government, I thought that's something that they'll take because it's very tangible, very clearly fits into the federal fraud statutes. But I have to say that now, seeing the statutes cited in the target letter, I think the contact with, of course, the interview of Raffensperger and now this contact with Doug Ducey, it does fit in a way. If you think about the testimony those two might be able to offer that could support this theory that the former president engaged in an effort to deprive citizens of their constitutional rights to vote, right? So Ducey can get up there, likely give testimony about contacts that he had from Mike Pence and possibly direct from Trump, certainly Trump's attempts to contact him, what he knew they wanted him to do with respect to certifying or not certifying the election. So I do think that there could be some very relevant testimony. Could be. Again, we don't know what the results of these interviews or appearances have been so far, but it's certainly a valid direction for the special counsel team to be looking right now. It's a little surprising that they left it to this late in the game. Maybe the selection of that 241 statute was kind of a late addition to the target letter. Maybe that's something they've just started thinking about differently in the last few months. I don't know. That's speculation, but
now it seems to me that, early on when they started looking at the fraudulent elector scheme, which started in November of 2021, by the way, not April or May of 2022, with Wyndham at the top of that. He's the guy who went out and he used the inspector general and the postal inspector to get Eastman, Perry, Clark, search warrants for phones and emails and things like that. And he started that fairly early on. And then I think what happened was the states started their investigations too. We know Michigan did. Arizona did not, because at the time they didn't have their new attorney general yet at the time. Georgia, everybody started looking. And then it got to a point where after the January 6th Select Committee was done and the government had all of its transcripts and could really begin its work of understanding what witnesses are good and which are compromised and stuff like that, that's when they maybe were in communication with some of these states and saying, hey, Dana Nessel, we got the Trump stuff. We got the Trump, Eastman, Chesebro, Meadows Rudy stuff. You deal with your own electors on the crimes. And so maybe that then, and we know Fani Willis's electors weren't given their immunity deals by their lawyer, and that sort of postponed everything for, my goodness, almost 9 months, right? So there was probably a lot of that happening, and maybe that's why finally that there's going to be a situation where in order to decline to prosecute something, you have to have all your reasons and your ducks in a row. So it seems like if they're not going to go after the Raffensperger and the Ducey stuff on the federal level, but they've got it so that they know that it was more appropriate. They could put it in the report that it was more appropriate for the states to do those investigations or something to that effect. I could see that probably being a reason for doing this so late stage, like that. They weren't really going to go after the fraudulent electors, didn't really need Doug Ducey or Raffensperger, but in order to get it in the report for a declination decision, you would have to definitely wrap up every loose end and every thread that you were investigating in the first place. And I think that might be part of it. I'm just guessing, though. I'm really just spitballing on that. But I think I find it very interesting that Doug Ducey, who took the phone, looked at his phone, hailed to the chief, silenced the call, put it down, and then signed the Biden certificate.
Certifying? That was too perfect. I mean, that was like a Hollywood moment. You couldn't recreate that in a believable way. Mm-hmm. Yeah, I think I just think whether they're taking the fraudulent electors thing as a federal crime or not, put that aside. Guys like Raffensperger and Ducey have some potentially important testimony to add to this overarching idea of defrauding the government or depriving people of their rights. Yeah,
exactly. Another bit of news: in a grand jury subpoena dated May 31st, Georgia's Secretary of State's office was directed to hand over any and all security video or security footage or any other video of any kind depicting or taken at or near the State Farm Arena and any associated data. This is Jack Smith, special counsel, subpoenaing video evidence from State Farm Arena. This is the video that Rudy Giuliani is being sued over for defamation by Ruby Freeman and Shay Moss. This is the lie, the big lie that Donald Trump fundraised off of consistently, sending the video out in fundraising emails, saying, look at the suitcase under the table, et cetera, et cetera. Look, she's handing off a thumb drive, which was actually a ginger mint, we found out later. So it comes to no surprise to me that Jack Smith would want this video footage perhaps to look at defrauding funders in the wire fraud case, but certainly also election interference.
Yeah, I think there's a lot of potentially interesting investigative avenues here. This is presumably security video footage taken that's, normal capture that's from cameras that are installed and run by the arena, which does raise a strange, the interesting question of like why they are going to the state Secretary of State's office to get this footage. If they're really interested in the footage, why didn't they just go to the arena and say, we want your footage? Maybe they didn't record it, keep it, maybe they recorded over it or it's no longer available, something like that. But there's a bunch of things they could be looking for here. So that security footage could reveal the actions of other people who were engaged in trying to watch or tape or film what the election workers were doing, right? So it could be a way of identifying additional people who are currently unknown to you, but who are actually on the ground carrying out the orders of a Rudy Giuliani or whoever else. And
that's a good point.
That if your theory is pointing to the what happened in the arena as evidence of fraud, knowing that it wasn't, you were defrauding the government or what have you, you would want everybody in that chain, not just, Rudy who was yelling and screaming about it on television, but you want the guy, the operatives or the people who went there to capture that video, to hand it up the chain as quote unquote evidence of fraud.
Yeah, no, it makes total sense. Again, I think as we hear more about these subpoenas, it just sort of speaks to the breadth and depth of the investigation, the sprawling nature, and the enormity of the investigation into the disruption of the peaceful transfer of power. All right, what did your colleagues over at CNN find out? This is new reporting that came at the end of the week.
Yeah, this is pretty amazing. So you have this really impressive team of Paula Reed, Caitlin Polantz, Kara Scannell, Hannah Rabinowitz, and Jeremy Erb that have stumbled across this information that prosecutors have been in talks with at least 2 witnesses to schedule interviews with investigators that won't be completed for at least another month. They also were able to uncover the fact that former New York City Police Commissioner Bernie Kerik, who is a very public Trump ally and somebody who is working very closely with Giuliani during that period of, let's find the evidence of fraud. Kerik was like, the former law enforcement, super cop who was actually going to go out there and find the evidence of fraud and deliver it to Giuliani and the other attorneys. Well, apparently Kerik is still in the process of scheduling his upcoming interview. And a former Trump lawyer plans to talk to investigators next month as well. So it's just a really solid indication that no matter what happens with the indictment, which, as I said, I expect to see that pretty soon, next couple of weeks, can't be much more specific than that at this point, the investigative work is going to continue here. So I don't think we should be surprised to see additional people going in the grand jury, even after the indictment, or other folks publicly acknowledging the fact that they're going in to talk to investigators, which is always, typically the first step before you end up in front of the grand jury. You got to go in and get interviewed first so the prosecutors know what you have to say.
Yeah, I think that's always, and I mean, this is when we were, watching the Mueller investigation. Those first indictments first started coming out in November of 2017, and the investigation continued and didn't end until the spring of 2019. So we don't know how long we're in for. We'll
be introing Jack 57. Indictment watch continues.
Dude, they just served a search warrant in the Tupac case, 27 years old.
That's crazy. That is
so.
Nuts.
Yeah, things can take a while. I don't think we're
they
looking
just
at
solved the
27
Gilgo
years,
Beach murders, we think.
Yeah, although I don't think that the Trump insurrection case is going to go cold for any time.
Let's hope not.
There's so much information. We're all tripping over it everywhere in the country. Also, let's see, from CNN, they say, for instance, the grand jury hearing evidence in Smith's investigation met for more than 6 hours Thursday. Mm-hmm. This is what we were talking about with the Wyndham and the Will Russell,
Judge McFadden,
Stanley Woodward, Judge McFadden drama. Before concluding, shortly before 5 p.m., CNN spotted members of the grand jury leaving the courthouse Thursday afternoon, and prosecutors with Smith's office returned to their office in the separate building. They go on to say in a sign that Smith's team could bring additional charges in the classified documents case. A Trump Organization employee who works at Mar-a-Lago recently received a target letter, and we remember that. We talked about that last week. That is probably employee number 2, also represented by Stanley Woodward.
The law offices of Stanley Woodward. He's doing more work than 50 attorneys combined at this point.
Yeah, yep. And he's getting paid handsomely by the Trump Save America PAC.
Yes, he is.
So we have some more news on the documents case, too. We're going to pivot over to the documents case and some rulings that have come down from Judge Aileen Cannon, but we need to take one last quick break. So everybody stick around. We'll be right back. All right, welcome back. The ruling we've all been waiting for has come down. Judge Aileen Cannon has set the trial date for the documents case, the Mar-a-Lago documents case, for May of 2024. And that is right in line with what our friend and guest Brian Greer had assumed we would eventually end up with a June trial date. But I think the problem here is that we wanted a December trial date with the regular order of delays to kick it out until May or June. Now we're all the way out in May, and any additional appeals for Cannon rulings a week before then could push this out beyond the election again.
Yes.
So I'm glad she scheduled it for before the election, but that doesn't mean she's not done delaying this thing.
That's right. And, it's really kind of an interesting decision on her part. I mean, I think on the surface, it looks kind of Solomonic, right? Split the baby. Jack Smith wanted this December, which by really all observers were like, that's pretty aggressive ask, but okay, good for him. And then, of course, the Trump team came back and said, we want it never, or otherwise known as sometime after the election. So giving them a date, which wasn't as quick as Jack wanted, but it's a date certain and it's before the election, it looked like kind of a clear split. But there's some...
Well, it's also kind of, and I don't mean to interrupt you, it's also kind of the next available date. His dance card for court is filling up pretty fast. January, February, We've got E. Jean Carroll. March, April, we've got Manhattan District Attorney. Judge Cannon actually asked if Manhattan could change their trial date because she had her eyes on March for this one. So, giving a little extra time for each of those trials. May is the next available time if you're not going to put it in December.
I think that's right. There's also reporting that she was very engaged in figuring out what the process would be with now the necessary hearings that we'll see through SEPA and motion practice and all that kind of stuff. So she made some effort to really kind of base this on at least solid predictions of what the timing might look like, maybe optimistic predictions of what the timing could look like. Also with an awareness, as you just said, of the other trials that Trump is facing. I take all those as good signs, right? She didn't just completely fold to this doom and gloom argument that the Trump attorneys made of, oh, he's so busy, he's not like anybody else, it's not fair, la, 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 la. She kind of summarily dismissed all that and went with something that is at least a decision that's at least based on some sort of reasonable logic and fact. And I don't know, maybe I have a very low bar here, but I'm taking that as a good sign. And consequently, coming out of the arguments on Tuesday, it looked like she was really very negative about the special prosecutor's asks. And I was afraid that she was going to go full on in the tank with the Trump side on this one. That has not happened. And I would assume that Trump's lawyers are a little bit stung by this one. I think they probably expected, an order that was more in line with what they wanted.
Yeah, it's a clear loss for Team Trump, which makes me think it's a win for the special counsel. But yeah, all right. So we're looking at now. We've got January, we've got March, we've got May. Let's see when we can line up a January 6th trial, and then we'll see where the Fulton County trial comes into play, and then who knows what else we'll have after
There's
that.
a full dance card for that old man. I'm telling you.
Yep. Every day is going to be the worst day of his life for the rest of his life. All right. So do we have some listener questions, everybody? We love our listener questions. If you have a question, you can send it to us at hello@MuellerSheWrote.com. Just put Jack. Make sure you put Jack in the subject line. Otherwise, it'll get lost in the shuffle. What do we have this week?
So this week, AG, we have a question from Christy, who hails from North Carolina. And Christy starts with a very cheery hello and an exclamation point. I love that. And then she asks, why might folks appear multiple times before a federal grand jury? And this is like an incredibly timely question in light of our conversation about Sir William Russell, who was testifying on Thursday for the severalth time. I don't know, second or third time. So Christy, there's a lot of reasons why this might happen. The first one that we've seen a lot is you might have a witness come in and they might refuse to answer questions under some sort of claim of privilege. And then you would have to maybe litigate that claim of privilege. And then if it was litigated not in the defendant or the witness's favor, then you would bring, they lose their argument. In other words, you would then have to bring them back to actually get them to answer questions on the record. There's other pretty mundane reasons too. You might have a witness in early on in your investigation, and then over the course of your investigation, you learn more facts, right, about things that other people did that you think that first witness could shed light on, or maybe you learn things about what that witness actually did that they didn't tell you in their interview or their prior appearance. And so you might call them back in to confront them with things that they've been hiding from you or maybe lying about. So you could bring people in because you've learned new information and now you have a reason to ask that person additional questions. And
right,
then,
like the Walt Nada is a great
that's
example
right.
of that.
There you go. And sometimes, even if you have a witness who's like cooperating fully and truthfully and is not a problem for you, so that's rare because they all cooperators usually cause some sort of problems. You might have them come in at one period when the grand jury is getting information about one series of crimes or one event. And then you would bring them back later to talk about a totally different event or a different series of crimes, things like that. So you see that a lot in organized crime cases where you might have one cooperator who's like your star witness and they know everything. They were there for all the homicides or all the extortions or whatever. They might have to come in multiple times to talk about different stuff. So there's a lot of reasons why people might have to come in more than once.
Yeah, awesome question. Thank you for that. Again, if you have a question for us, you can send it in to us by emailing us, hello@MullerSheWrote.com. Just put Jack in the subject line. All right. Well, as we say every week, what could possibly happen this week? We'll find out.
The Lord only knows. We might be talking indictments next week, or
more
maybe
testimony, more
know.
target letters. Who knows? But whatever it is, you will hear it on Jack, the podcast about all things special counsel. Andy, it's been a great show. Thank you so much for spending time with me. I'm Allison Gill.
And I am thankful to be here, and I am Andy McCabe.
We'll see everybody next week on Jack.